Hi, I'm Jessica. I'm a business management major, taking information systems and organizations in spring 2020. Today we're going to talk about COVID-19 and the impact that it's had on the United States bankruptcy courts, specific to the organizational response to legal affairs. I have a very unique perspective. I do work in the bankruptcy department of a consumer law firm, and I love my job. So the first thing we're going to talk about is just even the steps to file bankruptcy. Typically, the debtor provides documents to the attorney, which is a series of bank statements, tax returns, online documents they're required to fill out, questions that they have to answer, and we come across clients who are completely insolvent. No cell phone. They typically will use public facilities like libraries in order to fill out this information and to obtain it for us. And with the stay-at-home order in effect, the question then became, how can we help debtors get this paperwork to us in a timely manner? I know at my firm internally, we get on the phone with the client. I'm more than happy to work things over, ask them the questions, fill out the information on our end of it to try to help them along on this particular process. Then the next question for the courts became signature pages. Prior to COVID-19, they required what's known as wet signature pages, and that's where you actually print the paper, sign it in blue ink, and return it to our office, and then we would mail it into the court. And these obviously were going to be delayed if the court was going to mandate to still take them. So new law was put into place that said that we could accept electronic signatures, at least for the time being. The regulation on electronic signatures is that it had to have an audit trail. And an audit trail specifically, is an IP address stamp, a date, a time, the user, the computer information, the geographical information, and that's to protect the debtor that they are in fact who they say they are, and if there's ever a question of who actually signed the documents. And so not all electronic signing documents have audit trails. And so there's only two of them that I know of. And one of them, actually, you're only allowed to send one out for free a month to a client. And then it becomes a financial burden in order to be able to obtain these electronic signatures that didn't exist before. Thankfully, though, the other software is free, rather unlimited, and it locks the document so after the consumer signs it or after the debtor signs it, that you can't go in and modify any of the information. So that took care of the signature pages part of it. So now we have the paperwork relatively solved, we have the signature pages solved, and then comes the creditor meeting. The creditors meeting typically takes place at the federal courthouse. It is a very private event. It's only you, your attorney, the local trustee, sometimes the United States trustee comes in, and then any creditor who decides to show up to dispute your ability to discharge their debt. When COVID happened, though, all of these meetings had been pushed out 1 to 2 months while the court system tried to figure out what they were supposed to do. Not only are the meetings required to be recorded because they are public record, they needed to find a software that was easy both for the consumer, the attorneys, and the trustees and the creditors to use, but also a software that supported that kind of mass meeting where everyone could be videoed in the meeting at the same time. Everyone had an opportunity to speak. It recorded well, it sounded well, and they finally came up with one software that is mainstream now in the court system. There are still some outstanding legal issues, though, as far as creditors meetings are concerned that are unresolved, and that's the issue of cell phones. So if clients, again, are very insolvent, they don't have access to the internet, they don't have a computer, they don't have a cell phone, the question then becomes, how do these people attend their meetings? So currently the court system is allowing those particular special circumstance cases to be delayed, but there should be additional measures put into place, in my opinion, whether the court system sends a disposable phone, whether the court system sends a phone with, by messenger, by courier, and then it get the tablet or the cell phone does get returned, and then they can forward it to the next client, because it's really Not that it should be the bankruptcy court's responsibility to ensure that these creditors can go to their meeting. There is an economic obligation and an economic legal right in order for them to have a creditors meeting within a specified reasonable amount of time. The next issue that's still outstanding, in my opinion, is an individual who wants to file independent of an attorney. Bankruptcy attorney fees can be rather expensive. They can range you anywhere from $2,000 to about $4,500. And so currently only attorneys have the ability to file bankruptcy petitions online. Individuals do not have access to that. They have to manually go down to the federal courthouse and actually file their bankruptcy petition in person. So while stay-at-home orders have been in place, no individual has been able to file a bankruptcy. And so I think that's really unfortunate. Personally, I think everyone should have the right to be able to get online and to make this type of filing if they need to. But kind of in summary here, so there has been, the bankruptcy courts have worked quickly and diligently within the guidelines that they've been provided in order to help maintain and to be progressive within the filings. But there are still some things that could be done to help move us into modern society. Thank you.